Good afternoon, and welcome to Changes in Employment Law 2024. I'm Angela Housaye Ashley, founder and managing attorney at DLHA Law Group. I want to thank you for joining us today on this December afternoon. We're really happy to have you. Our webinar, Changes in Employment Laws, is about changes in employment laws, but also contractual changes and obligations. And you're going to learn some interesting things today. I want to just let you know that what you hear today will be meant to be an overview for you. It's not considered legal advice. To give you legal advice, we would need to sit with you, understand your circumstances and the facts surrounding your circumstances, and then apply the law to those facts before we could give you legal advice. But it's a good starting point to understanding the changes and what you need to know. We have a lot to go over, so I won't take long. First, I'd like to do some housekeeping items. We will have a question and answer session at the end of the webinar. If you want to ask a question, please use the Q&A box at the bottom of your screen, and we'll usually take them in the order in which they're asked. If we don't get to your question, please feel free to email us at info@dlhalaw.com, and you'll see that's at the bottom of each of the slides, info@dlhalaw.com. And if you just want clarity around something, or if you think of something after the webinar ends, please reach out to us at any time, and we'll be happy to communicate with you and get back to you. I'm going to introduce our speakers. First, we will have Lindsay Meyer. Lindsay's a senior employment attorney at DLHA Law. She leads our employment team in providing legal advice and representation to our business clients. She practices in both federal and state employment-related matters, and today she'll be talking about employment law updates that will impact employers starting in the coming year, 2024. Next, you'll hear from Deanna Maxfield. Deanna is part of our litigation team with a background in employment litigation and experience in state and federal courts, as well as arbitrations. Deanna will also be speaking about changes in employment laws. Last, you'll hear from Kellen Stevens. Kellen leads our transactional team, and he will be speaking about non-compete provisions in contracts and general enforcement around those agreements. And now I'm going to have our team close out their video, and I'm going to go over some compliance updates. Then they'll come back on to speak. First, let me talk a little bit about general to-dos. For your company, if you have employees, you always want to have a handbook. That's one of the most important things, and one of the first steps when we start representing an employer is to take a look at their handbook, make sure it's current, make sure it has all the updates, because that's the first place that will go, and you should go if there's an issue with an employee. And it's definitely the first place employees tend to go for clarification. So you want to make sure your handbook is updated, is compliant, and has any addendums that you need. Next, you want to make sure that you have workplace policies and procedures in order. Those can be outside of your handbook, just your general policies that you can update from time to time. You want to make sure that you have your postings current. Those are the required postings per California Civil Rights Department, your OSHA, wage orders, etc., posted in a visible place for employees. And if you have any questions about any of this or your handbook, you want to consult with an attorney who specializes in employment law. Next slide. With that, I want to turn it over to Lindsay Meyer, and I'll come back when it's time for question and answer. Lindsay?
Thank you, Angela. Good afternoon, everyone. Thank you so much for joining us today. As Angela just mentioned, I will be covering some of the updates that will be applicable for employers, companies coming into 2024. And the first one I'll cover is the new law requiring essentially all employers in California to have workplace violence prevention plans in place. When I'm speaking, I'll try to refer to it as the plan, just to shorten it a little bit. But back in September of 2023, it was signed into law that this new requirement that virtually every California employer is going to have to implement a very comprehensive workplace violence prevention plan, and it has many specific requirements. it also is adding a new section to the California's Labor Code, and that will be implemented and enforced by Cal OSHA as well. Now, the new law is requiring that employers make this plan effective and ready to go by July 1 of 2024. And employers can incorporate it into an existing injury, illness, and prevention plan, or employers can have it as a standalone policy or an addendum, for example, to their handbook. We recommend, because this is so new and there has never been a requirement like this in California before, this extensive, to have this type of plan in place, to keep it separate, because inevitably there may be additions or changes or other updates that potentially employers may even have to make in 2024. So it will probably be a lot simpler to just update the plan itself, the workplace violence prevention plan itself, than having to go in, if you put it as part of your handbook, for example, or another plan, like the injury and illness plan. If you incorporate it in that, it might make it a little more complicated for you to have to go in and update. So we recommend keeping it separate, but you could do either scenario would work. Notably, additionally, as part of this update to the law, the California Code of Civil Procedure was also amended, and it will allow employers some additional abilities to seek restraining orders to prevent workplace violence where necessary against its employees. Under current law, employers are already authorized to seek restraining orders on behalf of their employees if an employee has been a victim of violence or of a credible threat of violence, a credible threat of violence has been made against them. But going into as of January 1, 2025, so again, this is a little out, but it's already been passed, but it will not be in effect until January 1 of 2025. There are some additional changes, and one of them is that the employer will be authorized to seek a restraining order to protect an employee if the employee has suffered harassment. So previously they were currently employers are only authorized if the employee has been, subjected to violence or has suffered a credible threat of violence. But now the laws will be expanded, and so employers will be able to obtain a restraining order if the employee has suffered harassment. And in the past, this was something an individual could only do on their own. So what is harassment going to be defined as for this expansion for restraining order purposes? The harassment definition will include a knowing and willful course of conduct directed at a specific person that seriously alarms, annoys, or harasses the person, and that serves no legitimate purpose. The course of conduct must also be one which would cause a reasonable person to suffer substantial emotional distress and must have caused such distress. So again, this has a reasonable person standard to be taken into consideration when applying it. But again, it's just giving even more support to employees and the employer to protect the working environment and everyone within it. So that's good news, and it's a great addition. So back to the Workplace Violence Prevention Plan, who is covered. And I did mention that essentially all employers and employees are covered in the state of California with very limited exceptions. The plan does not apply to workers who are teleworking from a location of the employee's choice, or employers who are regulated by existing standards for the healthcare industry, for example. Additionally, and this will probably be the exception that could be applicable to most of you or some of you who are attending today, employers who have work sites with less than 10 employees. They will be accepted from having this workplace violence prevention plan in place, but only if the work site has less than 10 employees present at any given time, and it is not accessible to the public, and the employer complies with the injury and illness prevention regulations already of Cal OSHA. So if all those three requirements are in place, then the employer will be accepted from having this workplace violence prevention plan in place by July 1 of 2024. So what is workplace violence? Workplace violence is defined very broadly under this new law, and it's defined as any act of violence or threat of violence that occurs in a place of employment. It includes verbal and written threats of violence, of course, any incidences involving the use of a firearm or other dangerous weapon, whether or not an employee sustains an injury. But additionally, there, as part of this definition of workplace violence, there are also acts that are captured within the definition that some may think somewhat waters down the meaning of what workplace violence is, but it now includes a threat against an employee that results in or has a high likelihood of resulting in injury, psychological trauma, or stress, regardless of whether the employee sustains an injury. So here, you'll notice there's no reasonable person test. There is a reasonable person test applied when looking at harassment for the restraining order purposes that I just went over, but not for workplace violence. So a seemingly innocuous comment to someone could potentially result, and can be considered and defined as workplace violence under this new law based on the perception of the employee who received, the threat. So because this is such a broad definition now, we definitely feel there could be an uptick of reports of workplace violence, in particular once employees really start being educated and understanding what is considered workplace violence under this new law. So again, employers will have to be prepared for this, be ready to address it, and make sure they have all their policies and procedures in place ready to go, because we do anticipate that there will be an uptick in reports of violence given this broad definition. So again, enforcement begins July 1 of 2024. That doesn't mean to start working on your plan then. Now is the time, to start getting that plan together. It's quite comprehensive. There is a lot that has to be included in it. I will go over just an overview of what's to be included, but by no means is this an exhaustive list of what needs to be included. And currently there's no real template. There is, obviously information as far as what is required to be included. So it's very important to work with your legal counsel or reach out to legal counsel to ensure that your written workplace violence prevention plan is encompassing all that it needs to. So first and foremost, I just mentioned the plan must be in writing, and it has to also be easily accessible to the employees. It's something, again, we recommend that you would just distribute probably at the time that you either distribute your updated handbooks, or it could be a separate time if you need additional time before the first of the year comes to work on it and get it together. But it does need to be issued. We recommend at least it be issued and already going into effect in your own workplace prior to July 1 of 2024. The plans, as far as what to be included, again, not an exhaustive list, but they must include the name and job titles of the individuals responsible for implementing the plan, the methods that the company will use to implement the plan, procedures that the employer, for the employer to accept and respond to reports of workplace violence from their employees, and what the procedures will be as far as prohibiting retaliation against employees who make such reports. Additionally, the plan will need to cover procedures to ensure that the supervisory and non-supervisory employees are able to comply with the plan, and procedures to communicate with employees regarding workplace violence matters and how their report will be investigated. In addition to that, there does need to be a means put in place to alert employees of the presence, location, and nature of a workplace violence emergency, as well as evacuation and sheltering plans. And there also needs to be procedures set forth regarding how the plan will be investigated and corrected going forward to provide that additional protection for the employee. So in addition to the plan, so you need the written plan, but you also need a log to keep track of any and all workplace violence incidences reported. So the log itself is also relatively needs to be very detailed. So of course you will need to report or log the date, time, and location of the incident. What type of violence it was. For example, was it a physical act of violence? Was it a threat? Was it an individual? Was it two coworkers involved? Was it a family member who came onto the work site to commit the act of violence against another family member, etc.? So the report is required to be very detailed. Additionally, details regarding the specific location are important. They want details included. For example, was the attack in a poorly lit area? Was it inside, outside, etc.? So they just want all the details captured as much as possible, again, all going towards trying to work to prevent a situation like that happening again. And additionally, you want to make sure you include what the consequences were of the incident. For example, was an ambulance called, was law enforcement contacted, and what actions were taken to protect the employee from a continued threat. So those are two items that you have to make sure you have ready to go and in place no later than July 1 of 2024, because that's when enforcement by Cal OSHA will begin. And that is the Workplace Violence Prevention Plan and the incident log. And lastly, employers are required to train their employees. So it's not enough that you put the plan in place and you distribute it and you have the employees read it and return it back to you signed, acknowledging that they read it. You actually have to have a separate training session for them. So the training must be completed when you distribute the plan initially, and then it has to be conducted once a year thereafter. And so the training has to be provided to all employees, part-time, full-time, everyone's included. And so you're going to cover, the rules, regulations, definitions contained in the plan, how to report incidents of workplace violence, assorted corrective measures that will be taken, describe, the incident log, and have an opportunity for those employees to have a question and answer period at the end. And additionally, as far as saving all of this documentation, employers are required to maintain records of any incidences and all of their, policies and procedures over the years, potentially being updated for a 5-year period. So all of those records will be needed to be maintained for 5 years. So again, I covered a lot of information. It's quite complex and comprehensive. This new plan that California is requiring employers to put into place. So please check with your legal counsel. Make sure that you have a really good understanding of what the policy needs to include. And if you go ahead and draft it, make sure at a minimum you have legal counsel review it to make sure there's nothing left out. All right, and with that, next slide, please. Switching gears a little bit here, not surprisingly, in California, we now have an expansion to the California Fair Employment and Housing Act that protects off-duty cannabis use. This law goes into effect January 1 of 2024. And what it does is it prohibits employers from taking any adverse action against an employee based on that employee using marijuana off duty. So adverse action would be suspension without pay, a demotion, termination, even like a written disciplinary action. Anything along those lines would be prohibited if it were based upon an employer obtaining knowledge of an employee's off-duty marijuana use. And this also includes if the employer has a required drug screening, if there is any showing of the cannabis use in the bloodstream, as long as it has the non-psychoactive metabolites showing, that would be something, again, the employers could not use to discriminate against the employee. And employers on top of that, so on top of not being able to, use any information you get back from a drug screening that may be required, depending on what type of company you have, the employer also cannot request information from an employee or a job applicant regarding any prior cannabis use, or use any information that maybe have been obtained through a criminal background check, for example, relating to someone's criminal history, potentially relating to, again, cannabis use. Next slide, please. Of course, there are protections that were built in for the employer on this matter. So what this expansion does not protect or does not include, employees are not permitted to possess, be impaired by, or use cannabis on the job. So this expansion to the California Fair Employment and Housing Act does not impact an employer's right or the employer's obligation to maintain a drug and alcohol-free and safe workplace. So again, keeping the workplace safe for employees and anyone who comes in and out of the workspace is essential and is a requirement, obligation of the employer. So if, for example, an employee were to go on their lunch break and they come back impaired because they were smoking marijuana on their lunch break, the employer absolutely could take disciplinary action. Of course, always check with your legal counsel before you make any aggressive moves of discipline when there's new laws in place like this, just to make sure there's nothing that you've missed. But again, employer is not required to overlook somebody being impaired on the job. And that includes an individual even just possessing marijuana on the job. So absolutely, employers can keep their workspaces safe and drug-free. That's not something that the law is changing in any way. It's just that the fact that an employer may obtain information about one of their employees using marijuana off duty, that's something that the employer can not use against the employee in any disciplinary way. And with that, I will turn over to my colleague, Deanna Maxfield. Thank you very much.
Thanks, Lindsay, and thanks everyone for being here this afternoon. I'm going to talk about a few new laws regarding employee leave and compensation. All the laws I'm going to discuss go into effect January 1st, 2024. And the first law I'm going to talk about is California's expanded paid sick leave law. You may be aware that California currently has a requirement that employees receive 3 days of paid sick leave per year. And a lot of the details of that law are staying the same, but it is being expanded. The requirement is being increased to 5 days of paid sick leave per year instead of 3. And that the 5 days assumes an 8-hour day. So that's equivalent to 40 hours of paid sick leave per year. You can choose to provide that leave in one of two ways. There's an accrual method or an upfront method. The accrual method is somewhat self-explanatory, that it involves an employee accruing paid sick time as they work. If the employer uses the accrual method, they need to have their employees accrue 1 hour of paid sick time per 30 hours worked. And there are some other more complicated accrual methods that are permissible under the law. I'm not going to get into detail on all of them on this webinar. The 1 hour per 30 hours is supposed to work for most employers, but if for some reason that doesn't work, I would recommend consulting an employment attorney to have them help you design a system that's going to be compliant with the law. If you want to avoid all of that complication, you can also just choose the upfront method that involves just giving each employee an allotment of 40 hours of paid sick time at the beginning of each year of employment. That's rather simple. The one complication is that it needs to be per it needs to be at the beginning of each year of employment, not the beginning of each calendar year. So you can't just give everyone 40 hours of paid sick time on January 1st. It needs to be on their work anniversary. So you will be providing the allotment at different times of year, but otherwise you're just giving someone a bucket of 40 hours of paid sick leave per year. A lot of employers also use a combined paid time off system. That is okay if you have sick time and paid sick time and paid vacation time all in the same bank. That's fine as long as the employee is receiving as much leave as is required by this law, and they're allowed to use it for the reasons that are identified in this law. So as long as the employee is still getting everything that's required by the paid sick leave law, combined PTO is fine. Once they have the, let's go back to the paid sick leave. There we go. Thank you. Once they have the sick leave, an employee must be able to use it for diagnosis or treatment of a medical condition of themselves or a family member. So that means that if an employee has a sick child they need to take to the doctor, they should be able to use their sick leave for that. If they got hurt over the weekend and they need to schedule an MRI, they are permitted to use their paid sick time to go to that appointment and get the MRI. If the need for leave is foreseeable, the law says the employee should provide reasonable advance notice. So again, with the MRI example, that's almost certainly scheduled in advance. The employee should let you know in advance. But let's say it's a trip to the emergency room, those usually aren't scheduled in advance. So the need for leave is not foreseeable. The law just says that the employee needs to provide notice as soon as practicable. That's the phrase that's used. There's one other category of reasons that an employee can use their paid sick leave. Victims of domestic violence, sexual assault, or stalking must be allowed to use their paid sick time to seek medical or psychological treatment, receive services related to stalking or abuse, or to go to court related to the domestic violence or abuse. That would be, let's say they need to testify in a court hearing, or they need to go to court and seek a restraining order. They need to be able to use their time for that. Employers are prohibited from retaliating against an employee for using their paid sick leave. And that's pretty self-explanatory, but one thing that's a little wrinkle is that that includes giving an employee a point or occurrence under an attendance system. I know some employers have attendance systems where you're not disciplined right away for an unplanned absence, but you do receive an occurrence or a point under the attendance system. And then if the employee gets too many points, then they're disciplined. They can't receive any kind of point or demerit for using their paid sick leave. It's protected leave. Employees also have to be allowed to take partial days off, but the employer can set a minimum of 2 hours. So what that means in practice is, again, let's say that this employee needs an MRI, the clinic is right near the office and everything goes really efficiently, and they get back to the office in 90 minutes. It only takes them 90 minutes to get the MRI. You can charge them 2 hours for that time. You can round up to 2 hours and say, okay, that's 2 hours worth of your paid sick leave, but you can't charge them a whole day of paid sick leave for just a partial day absence. And finally, something that's interesting about this law and something that employers are going to want to watch out for is that the law actually does not provide any provision or there's nothing in the law that says the employer can ask for a doctor's note or other documentation for an employee to take this leave. It just says the employee is supposed to be able to use their leave upon an oral or written request to the employer. So the safest thing to do from a legal standpoint is to not ask for documentation for someone to use their paid sick leave. Hopefully that's not too much of an issue because it's only 5 days per year. But if you do have concerns about an employee's use of paid sick leave, I would recommend that you speak to employment counsel to make sure that you don't get accused of retaliating illegally against an employee for using their leave. Okay, next we're going to talk about bereavement leave for reproductive loss. This is another one that there's sort of already a framework, but California has expanded the leave requirement. This is also going into effect January 1st, 2024. So you may be aware that there's already a requirement under California law that employees should be allowed to take unpaid leave after the loss of a family member. But starting January 1st, employees are also going to be entitled to 5 days of bereavement leave for a reproductive loss event. And the law provides a few examples: miscarriage, failed adoption, failed surrogacy, stillbirth, unsuccessful assisted reproduction. Basically, if without the event happening, the employee would have become a parent, then it's a reproductive loss event, essentially. Again, this is unpaid time, but an employee should be allowed to use paid sick time, vacation time, if they have any kind of paid leave that they could use under an existing leave policy, they should be allowed to use that to cover this time that they take for the reproductive loss. It does not have to be taken all at once. It can be taken intermittently, but you can limit it to within 3 months of the loss. And again, the cap is 5 days per event, but in the event that the employee unfortunately has more than one reproductive loss in a 12-month period, the employer can cap the leave at 20 days per year. So in a 12-month period, you can say no more. Sorry, accidentally muted myself. And finally, the law does require that all information the employee provides in the course of asking for this leave must be kept confidential. Obviously, there's going to be some pretty sensitive information that an employee might share. Some of it's going to be health information, which should be protected and kept confidential regardless. But anything that the employee shares with the employer regarding this kind of leave should be kept confidential. However, similar to the paid sick leave law we just discussed, this law does not have any provision for asking for documentation. So your employee may choose to explain to you what happened and why they need the leave, but there is no provision for asking for any kind of doctor's note or any other documentation for the person to take the leave. And this is actually unlike the original bereavement leave law, which does say that you can ask for an obituary, for example, to document the loss of the family member when the employee wants to take the leave. This doesn't have that. So again, hopefully it's the kind of thing that happens rarely enough that it isn't a big problem. But if you do have concerns about use of this leave, you should contact legal counsel before you take any disciplinary action. And finally, I'm going to be talking about the new minimum wage in California starting January 1st. You have likely heard about this. The minimum wage has been increasing for a while. Starting January 1st, the minimum wage is increasing from $15.50 to $16 per hour. Pretty simple for hourly employees. Something that many people may miss because of this increase is that the minimum salary for exempt employees is also increasing. So an employee that's exempt from overtime rules and doesn't get overtime needs to make a salary that amounts to at least twice the minimum wage, assuming that the person works full-time all year. So with this change, that minimum is going to be $66,560 per year. So what that means is if you have a salaried employee who is not receiving overtime because they're a manager or they fit into one of the other categories of exempt employees, they need to make at least $66,560 of salary per year, or otherwise they're not classified as exempt no matter what they do day to day. So it's just the kind of thing that people don't think about that often. And so it's just a good time to double check that your employee's compensation is compliant with those rules. It's also important to remember that the California minimum wage is a statewide floor. Cities and counties are free to have higher minimum wages. They can't have a lower minimum wage than the state, but they can have a higher minimum wage. And in fact, there are about 35 or 40 local governments in California that do have minimum wages that are higher than the state floor. I'm not going to read you a list of 35 different local governments, but I'll give you a few examples that are up here in Northern California. For example, the city of Alameda has a higher minimum wage than the state, the city of Berkeley, Emeryville, San Francisco. And to make it even a little bit more complicated, there are some local governments that have higher minimum wages than the state that are also increasing their minimum wage January 1st. So the city of Santa Clara, for example, already has a higher minimum wage. Their minimum wage is also increasing January 1st. The same is true of Oakland. And Oakland, in fact, has some wrinkles about if you're in certain industries, the minimum wage is different. For example, hotel employees. So obviously it can get a little complicated. You're going to want to check your local laws to make sure that you are paying at least minimum wage wherever you're located. And with that, I am going to turn it over to my colleague, Kellen Stevens, to talk about some contract issues.
Okay. Wow, I saw the Q&A blow up during those during that segment. So there's a lot that people are curious about. So I'm going to be focusing on a few changes in laws for 2024 that affect working in California. But I just wanted to pull back and start with the larger framework, because what these affect are basically restrictive covenants in California. Now, California specifically prohibits non-compete agreements in the statutory code and the business and professions code. And it says that any contract is void if it restrains someone from engaging in their lawful profession or trade or business. So this is why we call it the land of non-competes. This was enshrined by the legislature. And because of that, California has then interpreted court cases to expand upon basically employees' rights, but also between businesses as well. So this is what underpins it is a strong public policy to protect employees. So you can remember that as that's how we interpret what's going on. There are some exceptions for the non-compete prohibition. This is during a merger or a sale of a business, a dissolution of a partnership, or limited liability company. Now, there are narrow requirements within these, though. So, for example, when you're selling a business, it has to be all of the assets. It can't just be the washer dryer, or it cannot just be one aspect of the business's intellectual property. And if you're an owner in a business, it has to be for all of your ownership interests, not a mere fraction of it. Further, the court has looked at that, the general prohibition against non-competes, and determined that there should be narrow exceptions or narrow restrictions regarding the exceptions. So these relate to narrow geographic scope. An example of this is if you're a business that operates in California, only in California, the non-compete can apply to the entire world. However, courts do look at this and say, they look at where you are advertising and where you kind of reasonably could do business. So there was a case where, although a company only operated in 4 California counties, it was challenging the enforceability of its non-compete agreement due to a sale was challenged with respect to one of the other California counties. The court upheld it and they said, you could foreseeably work here, you just don't right now. So it was narrow enough, but it also has to apply to a similar business, right? If you work in shoes, you can't prohibit someone from selling telephones. And finally, if there's a non-solicitation component related to employees, it only applies to the employees that were there at the time the business is sold. So if there are new employees that are hired subsequently 1 year, 6 months later, it does not apply to those and you can solicit them. Now, on the next slide, I want to go over how courts have slowly dismantled restrictive covenants in California. Remember, there's the public policy that prohibits, an unlawful restraint on trade. And there has been specific focuses with different court cases in the California Court of Appeals and the California Supreme Court that is focused primarily on clients, customers, and employees. So thinking about clients and customers first, there was a case in 2008, which broadly looked at enforcing non-solicitation agreements with respect to customers. And it found that non-solicitation agreements with respect to customers were generally not permissible. However, you could prohibit someone from using your trade secrets or using your confidential information in order to procure customers. But it couldn't just be the fact that they were procuring the customers. If they were using assembled historical data about customers that was competitively, that was pursued and competitive in the industry and not well known, then that is considered perhaps a trade secret. Trade secrets are protectable and there's a right to enforce action against them or against the misappropriation of them, but only if it was a trade secret and to an extent confidential information. With employees, there was a case recently called AMN Healthcare, where recruiters signed a non-compete agreement or a non-solicitation of employees. They went out on their own. And then what do you know? They started asking their former employees, why don't you come join us? The first company sued them and the court said, their whole business is recruiting. You're basically stopping them from engaging in the business. And per section 16600, no contract is supposed to stop someone from engaging in business in California, or lawful business anyway. Therefore, it was overturned. They rendered it void and unenforceable. And they did this on the premise of, let's take this really big public policy enshrined in this one statute and start applying it to the facts and circumstances. And the effect of that is that more and more, certainly non-compete agreements, but also non-solicitation agreements with clients, customers, and employees have been toned down. They've been limited. And what that in effect does is it creates more protections for the workers, but it means that you have to be more careful as a business with respect to what you have in your contracts. And you really have to limit the language that's in there. I did mention at the beginning of this that there were some new laws, and I'm going to go over those right now. So the primary law here that I'm going to talk about is SB 669. This is on the next slide, and it becomes effective January 1st, 2024. This changes the risk calculus for all businesses. Before, you could possibly have restrictive covenants with respect to employees, customers, or clients. And the damages were just specific, usually restitution, right? Paying someone back for what you lost. But here, the SB 669 authorizes damages, injunctive relief, And attorneys' fees and costs, which are often quite high, and when attorneys agree to take a contingency matter, they will more likely sue. So there's more likely to be litigation. But it doesn't provide a corresponding right for employers. So if a restrictive covenant in an agreement, employment agreement or otherwise, is challenged, then if the employee prevails, they have access to all this different type of relief. But if the employer prevails, they don't get any of it. So like I said, it's a big change in how you look at, as an employer, is asking to limit someone, is trying to enforce non-solicitation agreements, is it worthwhile or not? So it changes how we look at it. Also, SB 669 renders unenforceable any non-compete agreement, even if it was legally entered into in another jurisdiction. Prior to this, California, like most states, were respected the laws of other jurisdictions. They would enforce the laws of other jurisdictions as long as those were entered into legally. So if there was another, South Carolina, Nevada, Wyoming, if they permitted non-competes, or maybe like in limited circumstances non-competes, much like California does with a sale of a business, if they permitted those and the person moved here, California would enforce that non-compete agreement as a deference to the other state and their laws. But beginning January 1st, 2024, California says, if you move here, then we protect you as if you originally signed it here, and we will not enforce that. So that's just something as a business you want to be aware of, how that can impact your employees. So maybe if you're considering hiring someone new and they're worried about a non-compete agreement, you can say, well, they won't enforce it here, right? If it was previously signed in another jurisdiction. But also if you work across multiple states, you want to be aware of that as well. So that is the very limited overview of some changes to non-compete, non-solicitation, and other restrictive covenants here in California. And I'm going to turn it back over to Angela now to enter into our Q&A.
Thank you, Kellen. And thank you, other webinar presenters. I really appreciate it. We got a lot of questions. So let me see, we have about a little over 10 minutes, maybe 13 minutes. We're going to try to get to as many of these as we can. The first one is from Erica, and the question is it okay to make the workplace violence prevention plan accessible electronically only, or does it have to be provided in a printed version for the employees or any government agency? So that one I'm going to turn over to Lindsay.
Thank you, Angela. Great question. As far as the law, again, it's brand new, so things could change, but as long as it's made easily accessible to the employee. So you'll definitely, if the employee requests a hard copy, the employer absolutely should be able to provide one or have it accessible for the employee online or electronically to print. But again, if it's easily accessible, meaning it's made available online, that should be sufficient. But, again, if an employee does ask for a copy, that technically would be considered potentially as part of an employee's personnel file if it's a policy that they ultimately sign. So there are regulations under the labor code that require employers to provide copies of an entire personnel file. So if even a document of that nature was requested, I would certainly go ahead and give a hard copy if that's what an employee is needing. But generally just making it online should be sufficient.
Okay, thank you. Same person asking the next question, is the violence prevention plan requiring a separate employee signature, just like an anti-harassment documentation, or can it be bundled up with the handbook, signature included there?
That's a good question. As of right now, it's stating that you can combine it into an already existing injury and illness prevention plan. So technically you could have one signature if you're making it a combined plan. So they're acknowledging, both of the plans. And so if you have that all bundled into a handbook, that will be acceptable. But I do recommend that you have that policy be separate and get a separate signature, just because it's so important, as far as how it impacts the well-being and the safety of the employees. And I do feel that OSHA is going to really be coming down hard on companies that don't have adequate policies or no policies in place. So just so you really protect yourself, I think I would make it separate. And that way, if there's any changes or things that need to be updated, it's easier just to update that individual policy than have to go back in and update the entire handbook, which might change just even numbering, pages, etc. So I would personally recommend keep it separate, but you can bundle it. That's fine too.
Okay, great. Yeah, I know we usually separate them out. And that way, if there's modifications, they're not part of your overall handbook. Next one's from Katie, and this is for you too as well, Lindsay. Can you use sick pay accrual for one employee and upfront for another employee, both in the same organization?
That is a very good question. We get a lot of questions along these lines when it comes to sick pay and vacation pay. Now, as far as sick pay goes, if you're going to have a section of employees, like for example, all of your non-exempt employees are on an accrual method, that's fine as long as you're treating everyone the same, everyone's getting the requisite amount of hours. And then you have another sector, maybe all of your exempt employees are getting a lump sum. You just don't, I feel like it would be getting in a very sticky zone. It could potentially be have some exposure for the employer if they're just picking employee A and B. We're going to give lump sum, but then everyone else, even if they're technically all similar situated employees, we're letting them having them do the accrual method. For example, there could be some potential issues with favoritism, potentially discrimination complaints. So again, it's very factually specific. So if you have a certain situation in mind that you want to run by us, we're happy to look into that and give you very specific advice about the scenario. But again, when you're going to be treating different employees differently, you always want to tread very lightly and make sure that there aren't going to be any issues that potentially will expose your company to any type of liability, in particular by treating individuals differently, based on discrimination, etc. So,
Okay, thanks, Lindsay. Next one is, and this I'm going to have Deanna answer if you could. If we provide upfront sick time and they terminate, do we have to pay out the sick leave?
Right, that's a good question, because that's one of the big differences between paid sick leave and paid vacation. So paid sick leave under the paid sick leave law does not need to be paid out upon termination. There is one caveat to that. If you do use a combined PTO system, like I mentioned, where you're lumping vacation and sick time all together in one bucket, you do have to pay that out upon termination because the state is assuming that any of that could be paid vacation time. So you do need to pay that out. But if you keep them separate, then, or if you don't provide paid vacation time, you don't need to pay out accrued paid sick time upon termination.
Okay, thanks, Deanna. Next one, I'm going to ask you to answer as well. Can an employer require an employee to provide documentation proving that the sick leave was used for an allowable purpose? That's a great question. I know we get a lot of these.
Yeah, and it's counterintuitive because the answer is no. And I know that employers are probably used to asking for a doctor's note when someone takes a sick day off or someone requests a longer medical leave. You can ask an employee to get a certification from their doctor. But if they're using any of their time that they're provided under this paid sick leave law, if they're using any of those 40 hours, you can't ask for documentation. So if they've used up all of their paid sick time for the year and they're asking for some additional medical leave, then obviously, depending on what kind of leave they're requesting, you may or may not be able to ask for documentation. But if they're using time out of this 5-day paid sick leave bucket, you can't ask for documentation.
Okay, thank you. This is also regarding sick leave, so I'll have you answered if you don't mind, Deanna. Given your example, can you charge 2 hours to salary exempt employees?
Yes, you can charge an exempt employee for a partial day absence. You can deduct from their paid sick leave bank.
Okay, great. Lindsay, here's one for you. For a 5-day leave, is it additional to sick leave and normal PTA? PTA leave or normal PTO?
If I'm a little unclear on the
PTO.
question.
Yeah.
So if you can have a doctor's note, is that what the question is, Angela?
I think so. It's actually regarding, I don't quite
I know what the
Okay,
question is.
it was regarding a
If I-
screen that they saw, and then they said,
Yeah.
Oh, okay.
we don't have the screen up.
No.
If I might, I think this is about the reproductive loss bereavement leave, I am guessing, because this is something I was actually thinking about while I was researching. The reproductive loss bereavement leave law actually says that it is separate and in addition to any other leave. So it's its own, that the 5 days after a reproductive loss event is its own time off. And now it doesn't have to be paid. So you don't have to, the employee isn't going to have a bank of time that you're deducting from, but it's its own thing. So it's in addition to other types of leave.
Oh, I see. So one thing, Gianna, I think I can clarify too, and even further is if someone has 40 hours available of sick leave, the bereavement leave or the reproductive loss leave, that all can be taken unpaid. So they don't have to use any of their sick leave at all. You can't force them as the employer to take any of it. But if they want those days to be paid, they can go to their bank of 40 hours of paid sick leave and use that time, or they could say, I have, 40 hours of paid vacation time in my vacation bank. I'd like to use some of my vacation time. So I'm actually paid for this time I'm out on bereavement. So that's how they work together, if that makes sense. But yeah. It gets
that's a good point.
It does get confusing.
Yeah.
Good to know. Yeah. Okay. Thank you. Next question, and this one's for Kellen. And it says, so I'm understanding that a geographic restriction only applies during a sale or dissolution, and that it's not good for general business day to day. Do you mind answering that one?
Yeah. Thank you for asking me a question. I like to feel included here. It's kind of a yes, maybe, and no. I'm so sorry. So the geographic restriction is part of how a court narrowly interprets their exceptions to prohibiting non-compete. So first off, you can't have them, except if it's a sale of business. And then even if it's a sale, it has to be narrowly tailored. And so that geographic restriction applies in that way. So it's just kind of meeting the bar more narrowly each time. And if it is, then it's acceptable. And I'm not sure the general business day-to-day, you can't really prohibit people from competing in a certain geography. There are some exceptions, like when you sign a franchise agreement, but then your franchise, I'm not going to get into that, but so there are some, but typically no. I mean, there wouldn't be a reason to do it. So in a sale of business where it does occur, it has to be narrowly, geographically narrow. Okay.
Thank you.
You're welcome.
I think we have time for one more question, just so we stay on target, maybe two. So let's see how far we get. I do want to end at 1 o'clock, but I do encourage you, if we don't get to one of your questions, to please, like I said, email us at info@dlhalaw.com, and we'll be happy to answer it. Next one, do we have to cap sick time at 10 days minimum? And so that's a little confusing because it talks about capping, but it says minimum. It might mean allow 10 days or I don't know. Lindsay, do you want to address this and maybe take it as a maximum and minimum question? So we address it, we're sure to cover it.
Sure, yeah. As far as sick time, as long as you're providing the requisite minimum, which is now the 40 hours of paid sick leave, that's all you have to provide. So you must provide the 40 hours. You can do that as an accrual system, as Deanna previously explained, or as a lump sum at the beginning of the year. So 10 days is not a minimum. So I'm not sure if there was another question or there's something having to do with 10 days specifically you might have a question about. So please reach out to us, but you absolutely can give more. There's a lot of companies that have more generous sick leave policies. But if you have, for example, a combined PTO policy where you have sick and vacation leave combined together, and you at least provide 40 hours of time, you don't have to, again, provide any more either. So again, it's recommended really to keep them separate, but some companies like to have a combined, but it's easier to keep track of the paid sick leave and the paid vacation if you just keep them separate, and that way you can just provide the required minimum of 40 hours if that's what works best for your organization of the paid sick time. And then if you offer any additional vacation pay, that's a separate bank of time.
Okay, the last two questions that I want to pose are pretty good. So we might go a little bit over 1 o'clock, but you can, log off if you have a hard stop, because we do get asked a lot of these questions when we're preparing handbooks. When we prepare handbooks, we go through that company's sick leave policy and vacation leave policy very carefully because there are a lot of different nuances. But let me take this one. Are you able to ask for documentation for sick days? And I know we did discuss documentation, but this is a little bit different. Are you able to ask for documentation for sick days when it's been consecutive days? I know it used to be 3 days and then a doctor's note was required. Is that no longer the case? Lindsay, I'm going to give that one to you if that's okay.
Previously, because the sick leave requirement was 3 days of paid sick leave, so if it went past 3 days of time, people were asking for a doctor's note. You can always have a company policy where you request a doctor's note. You just can't condition taking any of the paid sick leave time upon actually receiving a doctor's note. When someone's going to be consecutively, absent, and it's going to go past now 5 days of time, because now the sick leave has been increased to 40 hours. So that's 5 working days, essentially. A company, you can request a doctor's note, and that would change then to the dynamic of the type of leave probably being requested, because anything past that amount, likely the employee will probably need to be requesting, a different form of protected leave, California, like under the California Family Rights Act, or FMLA leave, federal protected leave. So that's a little different. But for those types of leave, you can request medical certification from the doctor.
Okay, great. And then last question, and there are a lot of questions today, which is fantastic. I do see some clarifications to questions. So again, please do email us directly and we'll be able to answer you. But regarding sick leave, did you say you could not give everyone sick pay at the same time? Their example is at the end of the year, our company closes. Can we pay out their sick leave instead of vacation pay? We get this all the time. This question at the end of the year, can we close? Can we require them to pay? Can we require them to take vacation? But this one's about sick leave, paying it out at the end of the year when they close. Lindsay, do you mind taking that one?
Sure. Yeah. No, as far as the sick leave goes, if you're doing the accrual method, and Dion, you can weigh in here if you want to, but that you do have to allow them to carry over a certain amount. But if you are, as long as you're giving them a lump sum of sick leave, for example, of the 40 hours, you can make it to where they have to use it by the end of the year, as long as of the first of the next year, they have another 40 hours accessible for them to use. You never have to pay out sick leave. So it is a little different. So it's actually probably easier for the employer to do the lump sum sick leave. Probably everyone will use up all their sick leave. That's probably what will happen if you give the 40 hours, and then you'll just give the lump sum again of 40 hours the next year. So it gets a little confusing because people think of vacation. If it's combined into a single policy, then it's different, because now that also it's combined with it's PTO, so it's vacation and sick. So that is their time. So you would either have to pay them out all of it, or you would have to let it roll over. But you always have to, for each year, have the employee have the ability to take up to 40 hours of paid sick leave.
Deanna, did you want to add anything?
I think Lindsay got it.
Okay. Okay. Well, we really appreciate your participation, everyone, and having you join us. And we like all the questions. It's helpful because if you're thinking of that question, the likelihood is that someone else is who's watching. So that's wonderful. And it makes it more of an interactive webinar. So we want to thank you for joining today. I hope you all have a wonderful holiday season. Watch for our webinars. We give webinars frequently on different topics. And thank you again for joining us today. Take care.
Thank you.
Bye-bye.